Welcome to the special webinar that Schoeneck King is pleased to present. We're here today in the context of a decision that was reached by the Albany Supreme Court last week, in which the Albany Supreme Court annulled the fiscal intermediary rate methodology that was put into place by the Department of Health last summer. Understanding that there's probably many questions amongst the folks who are chosen to attend today about other CDPAP issues that are happening right now. If we have time at the end of the webinar, we'd be happy to try to address as many of those as we can. We can see the chat room, which is where those questions will be seen by us. And if you do have those kinds of questions, either about the main content of this presentation or the other questions you may have, we'll try to reach as many of them as we can. And following this presentation, we'll take a look at them and maybe reach out to folks individually to see if we can't be of assistance there. My name is Roger Bearden. I'm senior counsel at Schoeneck King. I'll let Hermes Fernandez introduce himself.
Yeah, hi, I'm Hermes Fernandez. I'm a partner at Schoeneck King.
And Jessica, would you mind introducing yourself?
Sure. Jessica Blanchette. I am an associate at Schoeneck King.
And we are all going to be both helping FIs navigate the consequences of this decision and try to help folks take advantage of it. So this presentation will be in three parts. We're going to start a little bit with what happened last summer and how that was a deviation from the way rates had previously been set. That's something I will cover. Then Hermes will turn to the litigation that we brought on behalf of both CD Paney's, which is the statewide association, and a number of individual FIs, and then what the court decided. And then we're going to spend some time talking about what's next as best as we can understand it at this moment. And this is an evolving situation since the decision just happened last week. So if you could turn to the next slide, Kathy. So then the next slide, please. So going to the world as it existed prior to August 1 of 2024, there are two forms of fiscal intermediary reimbursement, depending upon whether the claims are being in a fee-for-service Medicaid environment or a Medicaid managed care environment. As we know, about 95% of the claims are in managed care, but for certain subpopulations who are still in fee-for-service Medicaid, that runs through county DSS and then a direct bill to eMedNY. And there's a fee schedule that was set several years ago, a three-tier fee schedule that's set forth in state regulation. And that was the world as it existed prior to August 1, 2024. So if you could turn to the next slide, please. And similarly, on the Medicaid managed care side of the world, the rates were negotiated an all-inclusive rate as between inclusive of administrative costs and direct care costs. And then obviously each FI had a separately negotiated rate, which ran through the contracts between the individual FIs and the managed care plans. And in turn, the managed care plans were and have had contracts with the state Medicaid agency, DOH, and that's where they receive a single capitated rate for payment of all services that a particular Medicaid beneficiary might be entitled to. The next slide, please. And just a little further on that, that the regulation that established the three-tiered PMPM rate, it also had a provision in it that said that notwithstanding some paragraph 3, which was the 3-tier PMPM rate, the ability of Medicaid managed care organizations to reimburse fiscal intermediaries for their administrative costs pursuant to their provider contracts was not impaired. So there's a recognition in state regulation of that. And I will put a parenthetical here. Just this morning, the Department of Health issued new amendments to these regulations that are intended to implement the single FI process. Since these issued literally about 2 hours ago, this presentation is not going to be talking about what those regulations do, but I will observe that the regulations do in fact modify the rate setting methodology, which, as we'll get to in a little bit, is strongly supportive of the result in the court case that in fact modifications to rate methodologies do require regulatory activity. So to the next slide, please. So what happened? In May, on May 9th, DOH called the plans together for its regularly scheduled meeting with them and told them that it would be changing the rate methodology with respect to administrative cost reimbursement. So rather than having a single blended rate, they would be split as between a direct care rate and the administrative costs, and that, in fact, the FIs starting at the time, July 1, 2024, would be reimbursement according to the fee-for-service Medicaid fee schedule. So the 3-tier PMPM schedule that was set in regulation as applicable to fee-for-service Medicaid would be applied on a forward-going basis with respect to administrative reimbursement for managed care payments. Next slide, please, Kathy. So, and they had a PowerPoint presentation at that meeting, and it's quoted here in the slides that the plans would be essentially passing through the amounts of the 3-tier PMPM and paying the exact amount back to the FI. The next slide, please. So there was a slight change in June that they said they were going to delay it. So on June 28th, there was a second meeting with Medicaid managed care plans. They said that they're going to be delaying the effective date to August 1. I would note that nobody other than plans were invited to either of these meetings, and certainly not fiscal intermediaries as part of this change to their reimbursement. Next slide, please. So there was a material change as well, which is that under the fee-for-service methodology, the rates are determined based on hours authorized, which is a prospective measure. So at the beginning of a month, a plan would know how many hours a particular consumer had been authorized for, and then would be able to slot that consumer into one of the 3 tiers and make and understand what the payment should be. This changed, and once again, these are PowerPoints. So whether the words were carefully selected or not, I don't know, but this was the mechanism by which this directive was being given. And it said it was the number of hours received in a given month. So this was a change from how the billing was happening on fee-for-service, because obviously somebody may be authorized for a certain number of hours, but for any number of reasons, a hospitalization, the unavailability of caregivers, et cetera, not receive that number of hours. Once again, that was a change from the May PowerPoint that was established in the June PowerPoint. So the next slide, please. So, and then there was a May 2024 Medicaid update, and I put that in inverted quotes in the slides because it actually was published July 2nd. So it's sequentially it happened after, but if you go to that document, the PowerPoints are not on the DOH website, but the Medicaid update is. That document that is the May 2024 Medicaid update was in fact published on July 2nd. So after that June plan meeting, and it reiterated the previous guidance given to the plans, but this time it was a more public-facing document And it repeated what the June determination was, which was that it would be based on the number of hours, direct care hours consumer had received, as opposed to authorize, which had been the the regulatory standard for fee-for-service Medicaid. Next slide, please. And so what happened? And here's where I think so far everything is the same, and this is where there may be some divergence in what happened with specific plans and with specific FIs. So typically, at least in our experience, plans would send amendments to FIs to their contracts based upon the changed DOH requirements. So every contract prior to this change would have contained provisions around a single negotiated rate as between inclusive of direct care and administrative costs, and that would vary. That would vary from FI to FI, and it would vary from plan to plan. So you can kind of do the multiplication. If there's about 600 FIs, and I think it's about 16, 18, something like that, plans, you have a variety of experience that folks may have had at that time. And then FI reactions varied, and some entered into a negotiation, some protested, some did nothing, some signed things, some did a number of things, and I certainly don't have a complete inventory of all the actions folks may have taken in reaction to the plans. And we'll get back to that in the latter part of this, because some of what happened then may end up mattering now. And that's where, that's partly where, where the what's next conversation would go. So next slide, and I think I'm throwing the mic over to Hermes. Yes.
You are, okay. So thank you, Roger, for that great lead in. I have, and we can go to the next slide already, I have the least interesting part of this presentation, though it is the most consequential. We have a lengthy slide here, but the short of this is we sued and we won. We sued because the rate methodology, as Roger laid out, was not put together and done as a regulation. It was simply done as a means of administrative fiat. It was done through PowerPoints. It was done through oral presentations, but it was not done through regulation. And we had established in a case several years earlier that if there was going to be a change in the rate methodology in the consumer directed program, that change in rate methodology was needed to be accomplished by regulation. This is an important point. It is really a point regarding governmental organization and what authority state agencies have to make changes in processes and in the rules that apply to various programs, in this case, the Medicaid program. So we went to Albany County Supreme Court. There was, I think we can go to the next slide here. There were a few bumps along the road in terms of getting in front of a judge, but ultimately we were able to do that. We said to the judge, this case is controlled by the State Administrative Procedure Act. If the state intends to change a rule, which is a rule, and by a rule, we mean something that applies across the board in all circumstances, in all like circumstances, that is a regulation that must be adopted. And that change must be adopted through a rulemaking process. The rulemaking process is a process typically that in which the particular government agency announces a change in a proposed change in rule. They put that in the state register. You all, we, and others all can comment on that, explain to the agency, in this case, the Department of Health, why we think the rule makes sense or why we think the rule needs to be tweaked or the rule should not be adopted at all. The agency then must consider all those comments, and if it chooses to go forward with the regulation as proposed, it must explain why it's done so. if it decides to make some changes, it must explain those changes. None of that happened here. And we said to the court, that makes this directive from the department changing the rates and changing the rate structure inappropriate and actually illegal. The court agreed with us. I think we can go to the next slide, probably the next 2 slides. So the court agreed with us. The court took some time to agree with us. The case had been pending since I think we filed it in September, but we are here now. The court's decision that just came out in the last week, March 21st. Roger and I have been involved in a couple of other things that are making me lose track of time right now, but this just happened on March 31st. The Department of Health has 30 days to submit a notice of appeal, and then they have 6 months to actually go through the appeal process. That means submitting their briefs to, in this case, would be the Supreme Court Third Department based here in Albany. If the department doesn't do that, their appeal would lapse. When we challenged something very similar regarding fee-for-service payments in this same program, the department did notice an appeal. Ultimately, with only a couple of weeks left in their time to actually file the briefs, the department let us know they were not going to pursue the appeal, but that kept things on hold for almost 6 months. We don't know whether the department will appeal or not appeal. I would not draw any conclusions from the fact that the department proposed regulations today. I think that may be something that was, in fact, knowing how much work goes into those things, I think that is something that was in the works for quite some time and was unrelated to this case. But nevertheless, we don't know whether the department will take any action. The decision, though, is immediately effective. Right, the department is not entitled to a stay of the decision, which would mean that the decision is enjoined until the department decides whether to appeal. Right now, the decision is in effect. And going to the next portion of this program, we will discuss actually what that means and what you may be able to do. And as Roger alluded, what you may be able to do is maybe dependent on what you did previously. Did you sign a contract or a contract amendment when these rates were being changed? Did you refuse to do that? Did you do nothing? We'll go through those processes. Let's go to the next slide. So here we are. What's next? As I said, I had the least interesting piece of this. I'm going to kick this back over to Roger as we discuss what's next.
Hermes, you're more than happy. I'm more than happy to have you take this slide. I will say that
this
when
is what
folks
everybody's
look at
waiting for, actually. So let's get into this.
Yeah, and just in terms of the timing for folks, there's always a day or two between the good judge making a decision and it being formally entered on the docket. So if you've looked at the decision, it actually has a slightly earlier date. But that may be a more lawyerly point about when the clocks run. So as I said initially, every FI has a contract with each plan. Typically that would be based upon or wholly the model contract which exists. And each of those contracts prior to August 1 would have had a negotiated rate, which was unique to that particular contractual relationship. So then what happened? DOH said, well, okay, we've changed the rules of the game. And presumably the plans implemented, at least from what we knew of then, there was not necessarily any violation of the law by a plan if the program changes, the contracts typically allow for that type of unilateral amendment. Here's where the trick comes. Now that the Albany Supreme Court has declared that action by the Department of Health to be null and void, what are the rights that each FI has with respect to retroactive reimbursement and prospective reimbursement. I will say one of the if in fact the new regulations come into full force and there's a new SFI as under the statute as of April 1, we know the beginning date and unfortunately also the end date of the right to reimbursement because that will be measured between August 1 and April 1. But at least from I think our rough math, it's across the industry several $100 million of reimbursement, which is to be asserted as a contractual right as between the FI and the plan. So the first thing is FIs that we're working with, have begun to get out their contracts, get out there and understand what those contracts actually say. Anything else you'd say on this slide, Hermes, before I go to the next one?
No.
Okay, next slide, please. So as a matter of contract law, the first and most important thing when interpreting a contract is what are the words between the parties? What did they say to each other in that signed document? The next thing that can be very relevant is conduct between the contracting parties, and that's where we're talking about. And I'm giving a rough time frame, May to August, right? I don't imagine there's going to be actions that preceded the first plan meeting because the plans wouldn't have known anything before that May date that there was going to be any change from the way the world had worked prior to that. And presumably by August 1, whatever, or maybe a little bit after, if there was still some cleanup, that was the transaction, the relationship between the contracting parties was complete. So in addition to what the cold paper or electronic documents say as between the parties, you will want to understand what the communications were, right? Were there email communications as between the parties which establish an agreement or an amendment? Was there a unilateral amendment? Was there a protest? Did somebody protest but nevertheless sign? If they signed, what did they include next to that statement of their signature? All of these things are likely to be important, or either for asserting one's rights or potentially for defending against a claim that in fact you waived any ability to seek this reimbursement. It's difficult to give precise advice, right, because this is going to be dependent very much on the specifics of the individual relationship. And I'll throw it over to Hermes as well. Anything that you would add to that?
I think it's coming up in your next slide, so I'm going to hold back.
Thank you. Okay, so then the next slide, please. So the question, so this is I think really our last slide, at least for this portion, and then which is assert your rights. The decision is effective now. And the FIs should, or I suppose could, be pressing for the reimbursement, appropriate retroactive reimbursement. I add seek legal counsel because, two reasons. One, these are significant decisions about your contractual rights. Also, we don't want these slides to be interpreted as legal advice to any specific person on this webinar upon which they rely either to their benefit or detriment. But either way, you'll see the slide at the end of this presentation that reminds you that this is not the substitute for legal advice. Hermes, let me throw it over to you because it looks like you have some additional thoughts that you want to share.
Yeah, I want to actually give my prediction on, I think, what's going to happen and how this will play out. And this is obviously not regarding each one of you individually, but as a whole. My expectation is that, right, and I'm sure you all share this, don't expect any of the plans to send you a check, right? You're going to have to seek the funds, right? And Now, when should you seek the funds? As Roger said here, the decision is effective now. I'm not sure I would make the demand now. I'd probably wait until the appeal time is over, but you can make the demand now. You can say, we had rates that previously established. We were receiving whatever the number was, $250 an hour as our rate, or whatever the numbers were, right? And we've figured out that you were paying us this amount. We want the difference. We want it retroactively to the date that you plan changed our rates. The plans, I think, if they acknowledge your letters at all, will only acknowledge the letters. The plans are going to be going back to the Department of Health, and the plans are all aware of this decision. And they're going to say to the department, okay, what are you going to do now? Are you going to give us more? Are you going to give us more money? Frankly, we don't know if the department actually ever reduced the money it was paying to the plans. We believe they did, but that's not in our direct knowledge. So the plans, if the plans have received less from the department, the plans are going to say to the Department of Health, you have to make us whole. This decision said your directive was illegal. We were acting on the basis of your directive. Now pay us the money that we need to retroactively pay the FIs with whom we owe money. The department may say, well, we don't have that money to pay you now. And there may be some issue. That is not your issue, but that may be a part of your problem. Is if the plans don't feel like they have the money, they will dig in and take the position they don't have to pay you until the plan pays them. That doesn't mean you shouldn't assert your rights, and it doesn't mean that is a good defense. But we can see these things playing through as there's jockeying between the plans and the department. Now, the other thing I want to make clear to everyone is it doesn't matter what happens regarding the single fiscal intermediary. Whether you were in business after March 31st or not, this is retroactive. And for the entire period of time that you were being paid at the lower rate, you should be seeking to be paid back at what you previously received. Roger did allude to, or did speak directly to the fact that some of you may have actually signed contract amendments agreeing to these lower rates. You should still seek to be paid, but that will be one of the defenses that we expect your plans to raise, that you agreed to these changes. That will have to be worked through in terms of what you may be able to accomplish, but that is also something to consider. So I don't expect any of the plans to lay down and simply pay you. My expectation is the Department of Health will also be balky, but you will need legal counsel to pursue these matters.
So Hermes, if I could just try to do some live answering of a few of the questions that have popped up in the Q&A, and I appreciate those who were able to share some questions. There's a question, I'm just going backwards and where I can read them. Does the decision only apply to managed care, or does it also apply to fee-for-service? And the answer to that is the fee-for-service rates are governed, well, right now, right, there's changes afoot, but under the period of time we're talking, the fee-for-service rates were governed by the three-tier PMPM in regulation, and it was not a subject of the litigation that we're talking about. So that's so I'm just going to scroll back up.
Right. So your fee-for-service rates should not have changed. You were getting paid under those rates.
So there's a question about one of the attendees has been submitting under the old rate the whole time. If you've been submitting under the previous rate and the plan's been paying, I'm not sure how that happened, but you would not have a a claim for a retroactive reimbursement because you were in fact reimbursed at the higher rate. It does not impact the PPL award or anything in the SFI. Under the new regulations as they popped out this morning, they are going to be prospectively as of April 1st, have a regulation authorizing the rates that the SFI bid in the award. This is two on the same on this in the same train station, but two different trains in terms of that. Um, there's a question or more of a statement that says that it would be reasonable to go back to the pre-PMPM rates. I think that's probably the measuring stick that you'd have to go to. The question is whether the plans will agree to that view, whether your contracts would provide for that and your success or lack thereof in asserting your rights under those contracts. So yeah, I think the assumption is this is that the difference in reimbursement that would be potentially claimable would be the pre-August 1 rate, whatever the negotiated rates, because they vary by provider and by plan, and the single rate that was established post August 1.
Roger, if I could supplement that answer
Please.
as well, I think there's two things I want to highlight. One is this is one of those points where the contract will become important, right? What was your earlier rate, and what authority did the plan have to change your rate? I know, right? The plan, what we were seeing is the contracts that were presented to us typically said plans had the authority to change rates unilaterally if their rates were changed. So in those circumstances, right, this decision overturns whatever rate change the plans got from the department, right? So if the department changed what it was paying the plans, that's what the plans were relying on, and we go back to the original rate. Again, if you signed an agreement, you might have signed just an acknowledgement that the rate was being changed because of the department's directive. You might have simply signed an agreement that says you have a new rate, and there's no explanation for what the new rate is. But even in those circumstances, there was probably a letter or a communication from the plan that said this is why they're doing this, that they weren't just doing this out of the blue. I don't remember seeing anything from any FI that shared documents with us that didn't reference a plan acting at the behest or at the directive of the department.
Right.
The other thing, well, we talked about this very quickly in terms of you're going to try to collect the difference. Even if a plan is willing to pay you, there may be some period of time or negotiation in terms of calculating what the difference is, right? Because you were previously receiving flat rates. Now you receive, since the change, you were receiving a separate amount for administrative costs and a separate amount for direct costs. There may be accounting issues on how these things are calculated. Go ahead.
To that point, there's a comment in the Q&A, which is that there was the 1/1/25 direct care enhancement that came into play, which presumably was realized in an increase in direct care rates. So then there's going to be a further conversation about what the relationship between that direct care enhancement and what would have happened had the pre-August 1 rates been in place, and then the direct care enhancement would have come. So at the very least, it introduces additional complexity into the calculation that will be interesting. And there's also a
And
question.
I think all of you will probably take the position that that enhancement is yours it doesn't enter into these calculations. Whether the plans will agree with that is something different, is something else.
There's also a comment that says one of the attendees has already reached out to some plans, and those plans, at least one of those plans, has said got back to the commenter that that we can't at this time change payment methodology without further direction on how our reimbursement will be restructured. So, Hermes, your prediction of plan behavior appears to be shockingly accurate. And so, once again, though, I think the point here is your rights as an FI exist as a contractor to the plants. And I'm not taking a different example. If the state were to take an across the board reduction to plan rates, I'm not aware of any basis for the plans to simply say we've decided that we're going to unilaterally amend a negotiated contract. That's not here. What was different was the Department of Health said we're reducing. Whether they in fact reduced, I think is factually not known to us, but we're reducing it, but reduce it specifically in this particular manner by taking it out of the rates of this particular sector. So for those who may have, or that commenter and others who may have already engaged with the plans, you may already be having a conversation about a contract dispute. And I don't want to go further than that, because I think, I don't know enough of your specifics, but that's exactly the predicted conversations that are gonna happen, because the plans are probably not, as Hermes said, just busily cutting the checks, certainly at the order and magnitude that we're talking about, which is several $100 million based upon our rough math.
And if I could, I just want to. I'm sure it's obvious to all of you, but we are available to assist you in these tasks and trying to collect these funds. And Jessica is nodding. Jessica Blanchette will be working with Roger and me, and depending on how many people want us to assist others to do this. Jessica has become familiar with what this issue is and the steps we'll have to follow. I don't know, Jessica, if you want to add anything at this moment.
Nope, you've got it covered. First steps, like everyone has said, is just kind of identifying our contract, what happened, getting our facts in order. And we can certainly help you get going in that process.
And to the attendee who asked, I think our rough math is somewhere between $300 and $350 million. Is the value of this? I said several hundred million, not 700 million. But that's the math we did as we understood the magnitude of the reduction. It's a little bit of a complicated conversation to have on an industry-wide basis, since you're a little bit comparing apples to oranges, right? You're trying to make some predictions about the blended rate times utilization over the period of time versus these two tiers. But the cost savings that the state was seeking to achieve was in the several hundred, I believe about 500 million annualized. So we're just kind of taking the state at its own numbers. Each FI is going to have a very different calculation depending upon their own negotiated rates, the delta between the rates that they negotiated and the revenues received under the new methodology, and obviously their volume of business. So
there may have been a second rate cut that closely followed the change in the reimbursement methodology for the administrative costs, and that might have brought the entire number up to about 500 million. Right. What the court addressed was the change in rates that were directed by the department, which was the administrative portion, right? The 3 tiers. I know shortly after the department's announcements regarding the change to the 3 tiers came out, that there was also discussions that seemed to have been ongoing with the plans and with the department about whether the department was simply going to reduce reimbursement to the plans for other reasons apart from the administrative component. And I know that there were at least some plans that started reaching out and may have been implementing cuts with some of you at that same time. I remember that we were advising for folks when those cuts were happening, that if you were facing any of those cuts were not at the directive of the department, and the plans could not use that as use a directive of the department as a basis for a unilateral rate cut. If you were going to accept a rate cut on that basis, it would have to have been separately negotiated. So that's another complication here.
Yeah, and there's a question in the chat about the point made about hours authorized versus hours received. I think ultimately it's not going to matter. It mattered a lot for the sort of incoherence and the demonstration that it's better for government to maybe use rules rather than PowerPoints and memos to enact generally applicable standards that apply across an entire industry. What's going to matter for the retro reimbursement claims that you would be presumably asserting is what actually happened, so that can be measured in the, the revenue received subtracted out of the revenue expected, and there's going to be more debate, I believe, on the revenue expected side, which is to say, what would you have been paid if they hadn't have made that change? I suppose there could be arguments regarding volume, but I don't know that there's a serious argument to be made that the change impacted the volume, although it may have. I just haven't really thought it through. But the hours authorized versus hours received is more about why it's a good idea from a government perspective to actually follow the law, because then you can be clear about what you're actually doing. And one of the things in our papers we talked about was the hours received was a very uncertain measure under which FIs would struggle to operate, because you couldn't plan for it because you don't know how much. It's a retrospective measure. There is one question about the forward-going regulations. As I said, that we've just received copies, as I'm sure everybody else has. Those appear to be regulations that are intended to implement the single FI change, to implement both programmatic changes as well as fiscal changes that are endemic. So I think we don't have we've skimmed them, but we don't have considered views on them at this point. So I think we'd hesitate to speak more deeply to that unless Hermes, you've now performed a full study while also being on this webinar.
I use my third eye.
Okay, and then there's some specific questions about specific items that may have occurred in the course of conduct between plans and FIs, and I think I'm very hesitant for us to offer opinions on that, because there's going to be nuance there, and whether you look for BSK to help or your counsel that you go to on these matters, I think that's probably, those kinds of questions are best addressed by an individual consultation, and I don't want anybody to rely on us inappropriately. So there's a couple of questions, and just in terms of figuring out the delta between the old and the new rate, if you're going to be making a claim and if you're going to be seeking retroactive reimbursement, you're going to need to have an understanding of what you're asking for. So I do think that that's probably going to be part of your due diligence. Because if you don't know what you're asking for, I doubt that anybody's going to volunteer you a very generous number. That doesn't strike me as the way the world works. And in terms of rebilling by the old methodology, I don't think we're once again, I think that that's probably an individual conversation, but at least initially my recommendation would be not that you void existing claims and rebuild, but rather you're making a contractual assertion of rights. So we're near the 15-minute mark, and I think we've answered most, if not all, of the questions. Hermes, I don't know if there are any other items that, as we've progressed, that you think would be useful to mention in the context of this conversation.
I think we've covered everything we intended.
All right. So Kathy, would you mind moving to the next slide? And as I said, this is our standard disclaimer language, which thanks you for attending, but also reminds you that, in fact, none of this should be mistaken for legal advice that's specific to your situation, and that laws can change. Specifically, laws often change in the context of fiscal intermediary services, and you are advised to contact counsel for specific legal advice. We will, I believe, be able to make these slides available within a day or so. Usually it takes to get them out, as well as we make available a copy of this recording. So folks, we put this on with not a lot of notice, and we appreciate the 130 or so participants that were able to make it with about a 1-day notice. But certainly, if folks want to share this once we put it out with their colleagues who may be interested in what's happening, and we will make every effort to distribute additional information out as it becomes available, and certainly welcome providing assistance to anybody that may need it in this interesting space. So thank you very much, and I wish everybody a pleasant rest of your day.